The Supreme Court of Canada heard a very important case this week, and it has to do with something I've talked about on here before. The power that police have to randomly pull over vehicles and stop the drivers to check their licensing, fitness, and proof of insurance, as well as their sobriety. Essentially, what happened in this case, and the case is called Luamba, is Mr. Luamba was driving. He'd been, as a black man, subject to so many random traffic stops that it was disproportionate to people who weren't black. And he argued that the powers that were codified in the Quebec Traffic Safety Act, which are similar in every province and every territory across Canada, that allowed police to do that were unconstitutional in that they were effectively being used for racial profiling reasons, even though racial profiling wasn't written into the law, and even though there were police policies that say, don't racial profile, the police were doing it anyway. And his lived experience was proof of that. And the court accepted this. And the Court of Appeal accepted it when the government appealed. So the government appealed to the Supreme Court of Canada, who is now currently considering whether or not that law is constitutionally valid. You can watch the hearing on the Supreme Court of Canada's website. There were numerous interveners, people presenting views of the communities that they represent, like the Canadian Civil Liberties Association, the Association of Black Lawyers, the BC Civil Liberties Association, and so many other organizations. And essentially the argument of the Attorney General of Quebec in that case was that because the law says that there's these specific purposes for which a person can be pulled over, if a stop is done by way of racial profiling, which is outside of those purposes, that would be illegal, and the individual who's subject to that would be entitled to a remedy. The problem is that misses the point. And in fact, in argument, I thought that the lawyers missed the point often. The Supreme Court noting that if the law is being systemically abused, then there needs to be a systemic remedy. You can't just leave it to any individual case for a person to apply to the court for a remedy if their rights were violated because there's racial profiling. Also, because a lot of racial profiling stops happen as a result of subconscious bias rather than conscious bias, it's really hard to differentiate when an officer mouths the words of the legislation, oh, I stopped to check sobriety, oh, I stopped to request a driver's license, but in the back of their mind, they also had in mind the fact that the person who was driving the vehicle wasn't a white person. So all of these things are the real issues that the Supreme Court of Canada is going to have to grapple with. The questions show that the judges of the court are very concerned about this issue. But on the other hand, it has to be balanced against the fact that there needs to be effective mechanisms for the enforcement of impaired driving laws. And, Mothers Against Drunk Driving and other organizations dealing with that were present at the hearing for the purposes of talking about how impaired driving enforcement would be compromised by this. At the end of the day, though, we live in a free and democratic society, and if we give powers to the police that the police then abuse systemically, whether consciously or not, those powers have to be taken away. As the justices often asked counsel for the Attorney General, doesn't a systemic problem warrant a systemic solution?